We're unmuted, right? Yes, I'm muted.
Good afternoon. Can you hear me?
Yes, John.
Can you hear us?
I do. I don't see, I was minimally involved in setting this because I was in trial elsewhere, and I think you were working through it. My administrator Did anybody arrange for a court reporter or for the defendant's presence at this motion to recuse?
Your Honor, on those issues, I had not arranged for a court reporter. The defendant is currently being held in federal custody and has been having his presence waived at each successive hearing.
And we will waive that for this hearing as well, Your Honor.
Well, I guess for the continuance issue, we can proceed without a court reporter, but if we go any further, we're going to need a reporter. So has everybody reviewed the continuance that I received on, I guess I got it Friday?
We have, Your Honor, and we're prepared to respond whenever the court likes.
Okay, and Your Honor, I'm going to add one additional ground that did not become apparent to me until this morning when I received the defense's response, which is in their last section related to things that would have come out at the September 13th hearing. If they're going to seek to present evidence of that as part of their response to this motion to recuse, I need some time to gather witnesses to rebut what they claim the evidence would show in that regard. I mean, this is a surprise to me. I was not present. I was 150 miles away in Ruidoso, New Mexico on July 1st. So I don't have personal knowledge of what went on afterward. I have talked to a variety of witnesses. I have witnesses who can rebut their contentions in the motion or in their response to the motion to recuse, but I don't have those lined up for today.
Your Honor, Yvonne Rosales, the district attorney herself, and Michelle Hill, her assistant, were present during all this meeting that Mr. Briggs, who was at that time an assistant district attorney, was at. So even though Mr. Cox was in New Mexico when that happened, his boss was not. She was here and she knows what happened.
Okay, and my point is, I do not have those witnesses lined up for a hearing today because I did not anticipate any necessity of them being part of the hearing as I understood that it was likely to unfold. So if we're going to go into that sort of evidence, I'm going to need time to get rebuttal witnesses.
Your Honor, here's our problem, if I may. It surprises us a great deal that the state of Texas, the county of El Paso, the district attorney could have filed a sworn motion to recuse a state district judge and then come in the Friday before the hearing is set on Monday and give reasons why it was unable to prove its case. It surprises us even more so now that they remain unready, even more unready, when we point out facts that are well known to the district attorney herself, as we allege in our response, and to her assistant, Ms. Hill. So, and then so if the court looks at the first two grounds, if the court looks at the state's first two grounds, Mr. Cox says he has come to realize that it may be necessary to present documentary evidence, and he may have trouble authenticating it by Zoom. Well, I know I would, but that's why, by the way, Your Honor, I'm here today with Joe Spencer and Felix Valenzuela. I'm not sure the court has been introduced to those gentlemen, but we're all working on this case. But that's why old lawyers like Spencer and I get young lawyers like Felix Valenzuela who know how to operate Zoom and who can do the technology necessary to authenticate documents, which people have been doing for 2.5 years now regularly by Zoom.
Okay.
I'm sorry, Mr. Cox, go ahead.
I guess my response to that is, first of all, a lot of these documents, it's not a question of authenticating them. It was simply a question of the fact that in the courtroom, I simply hand the documentary evidence to the defense, and then I take it up to the court for review, and then I argue why it would be admissible, and I assume that I am opposed by the defense, and that is more cumbersome. But I was prepared to proceed. I sent out copies of all my proposed exhibits, many of which are more related to the context of what is going on in this case, as far as I can tell it. I sent those to the court and the defense for advanced review first thing this morning. because that was the best way I could think of to hand it to the defense and then take it up to the court for review aspect of things. I found it unexpected that the defense would admit to the existence of the extrajudicial investigation that is actually the gravamen of my motion to recuse, but apparently that's what the defense did by asserting.
I'm going to interrupt you there. We did not make any admission to an extrajudicial statement, so you shouldn't be telling the judge that, sir.
Okay, I'll leave it at that. My main point is this. I had no idea that you were going to seek to present testimony that I have witnesses who can contradict it, but I was not aware was going to be part of this hearing because I was frankly not aware that the defense was going to be, we filed this motion to recuse so that this evidentiary hearing entitled a status hearing could proceed on September 13th, at which we would present evidence of things that happened completely outside the case in chief in this criminal case. Now that I'm aware of that, I simply need time to gather the witnesses who might be able to rebut the evidence you're apparently preparing to present.
Your Honor.
And I do not have those witnesses available today because I was not aware that you were going to go where you're apparently intending to go with your defense. You have a right to present whatever defense you want, but I need time to procure witnesses to rebut your testimony.
Well, you haven't moved to do that yet, Your Honor. He hasn't, Your Honor. But also, we would point out that Mr. Cox's entire motion to recuse is based on either his personal knowledge or by information and belief by talking to other people. You would think surely he had talked to Yvonne Rosales, Roger Rodriguez, and Michelle Hill, and John Briggs. You would think surely he had done that before filing a motion to recuse Judge Medrano. And if not then, at least in the last 10 days, which he's had to get ready. And by the way, Judge, what we point out in our response to his motion to recuse is that this recusal is not something, despite what, with all due respect to Mr. Cox, despite what he says, it just came to mind, it was triggered, as he puts it, on September 6th. Judge, we'll have evidence, we'll have sworn testimony that at least as early as July 1st, 2022, representatives of the district attorney's office were telling the family and the victims in this case that, quote, we're gonna recuse Judge Medrano. So this is nothing new to them. This is something they've been planning for at least 2.5 months. And you would think that the state should be ready to go forward. Now, I suppose if he does claim surprise legitimately to the court, then he could ask for continuance at that time. But Your Honor, we are ready to go today. I just want to make that clear. And if the court will look also at his second point, Mr. Cox's second point, he has certain Mexican government documents to be translated. Which documents? What's he getting at there? I guess he's saying they're material to the case, but he doesn't give us any evidence of that in his motion. And he says, for potential use during rebuttal, and that's a ground for continuance. Your Honor, it's clear from the inadequacies in this motion that they are looking for any reason, however flimsy, with all due respect, to continue the case. And now they've added on a third one. We don't think it's right, Judge. We are ready. We have blocked off a day and even more. We've got a witness who is going to be gone tomorrow and the rest of the week at a legal seminar. So that's going to complicate things. The state has not given adequate grounds, good grounds, a basis at all, Your Honor, for continuing this hearing.
Do we have the court reporter?
Can we get a court
Yes,
reporter?
Judge, I'm on. I'm sorry, I got in a little bit late. I thought it was at 12.
Okay. Well, uh, uh, I guess what we're gonna need to do is when is, what was it set for, a status conference? What does that entail out in, El Paso?
Okay, based on my somewhere about 17 years of experience practicing criminal law in El Paso County, Texas, status hearings are traditionally concerned with scheduling, case scheduling issues. Has all the evidence been turned over to the defense? Does the defense feel they're missing anything? Is there anything that might delay the case that had not previously been anticipated? Relatively standard logistical issues. The status hearings that Judge Medrano has scheduled in this case have been anything but those, except for the very first one, November 7th, 2020. It's my memory of the day. That was a relatively standard status hearing. The new lead attorneys for the state were introduced to the court, and there was a discussion of scheduling matters. And as related in the motion, Judge Medrano made the statement, I'm planning to start scheduling hearings at the beginning of 2022. That's what a status hearing usually is.
Your Honor,
Status hearings have never, in my experience, been venues for the presentation of evidence. Admonishment hearings to scold a party to a case for perceived deficiencies, those tend to be called admonishment hearings or discovery hearings or things of that nature. Status hearings, by their label, tend to notify the parties only that this is going to be a relatively routine logistical conference.
Your Honor, could I say this? I want Mr. Spencer to give our side of that story about El Paso custom, but can I also say this in regard to this case? Mr. Cox knows perfectly well about what the status hearing first on August 18th was. He knows that it was rescheduled for August 13th on his motion so he could find his witnesses. But we also know that in relation to the September 13th hearing, before he filed a motion to recuse, he issued subpoenas he subpoenaed a man named Justin Underwood, a lawyer, representing that Mr. Underwood had material witness to give, and he filed along with that a lengthy, detailed subpoena duces tecum. So surely Mr. Cox is not representing that he expected something than an evidentiary hearing on September 13th. He obviously, when he filed that motion, when he filed that request to subpoena Underwood, he knew it was an evidentiary hearing. Now, if I can let Mr. Spencer speak to.
Well, if I might respond to that briefly. Yes, by that point, I knew that what Judge Medrano had labeled as a status hearing for September 13th was pretty unquestionably going to be an evidentiary hearing, because Judge Medrano had begun his investigation by literally ordering me to delve into a variety of information about happenings at the DA's office after the so-called status hearing on July 1st, and had also requested that the district attorney's office procure the attendance of the Hoffman family. His initial representation was, I'm just going to make sure that that they understand the gag order. His subsequent representation at the next meeting was, but they might say something when they're in front of me that will incriminate them in terms of contempt. So I'm going to appoint them an attorney. So yes, I knew the September 13th hearing was likely to be evidentiary in nature, because Judge Medrano had made that very explicit. He did not, however, change the name of the hearing to be discovery hearing or evidentiary hearing or show cause hearing for contempt or anything else. He left it as a status hearing, as he has continued to do with every subsequent hearing.
And Mr. Cox, or nobody in his office, asked for clarification. He didn't need it because he knew exactly what it was for.
Okay, what, the only purpose you were asking for an in-person, Mr. Cox, was because of the difficulty with the exhibits?
Yes, and I have since reconciled myself to the procedure I used with just sending the documentary exhibits in advance. So in person, I can work around that. Yes, Your Honor.
Okay, and the defense is not asking for in-person.
Well, Judge, our primary request today is that we have the hearing today. And so obviously that's by Zoom. I think, I always prefer a live hearing, but no, to answer the court's question, because it's been scheduled today, because we've made arrangements to be here and we're ready and we would like to have it done. We briefed this issue extensively, Judge, and we think it can be done pretty quickly.
Well, I'm going to grant the continuance for the limited purpose of him having everybody that he might possibly imagine that he may need, because we're going to finish it at one time. We're not going to piecemeal this. We're going to start and we're going to go straight through. So I have available Tuesday or Wednesday of next week. You pick, but we're going to start at 9 a.m. and we're going to go straight through, and it will be 9 a.m. Bexar County, San Antonio time. However, that relates out there. That's
That
going
would be 8 o'clock local time, Your Honor. And let me just verify the dates. So this would be the 27th or 28th.
I'll give you your choice of either Tuesday, the 27th, I'm sorry, Tuesday, the 27th, anytime during the day that corresponds with the opening of the courthouse out there, or the 28th, anytime that corresponds with the opening of the courthouse in El Paso. The other problem I have here is I don't know who communicated to the media, but they're blowing up my administrator's phone saying that they thought it was mountain time and therefore they're not present. So I don't want to be accused of violating the open courts doctrine, even though I am broadcasting it on YouTube as we speak, but they're having some kind of issue about logging in. I've got nobody in the waiting room. My YouTube channel is on YouTube and it's posted on the OCA site. So I can't imagine what their problem is, but we'll give them till one day next week to figure out how to attend by Zoom. So what's your choice, Tuesday or Wednesday?
I'm available both days, Your Honor.
I'm scheduled to be in Tulsa, Oklahoma for a federal sentencing on Wednesday, so I'd like to be able to get it on Tuesday.
For Tuesday, what time?
Early as possible. Your Honor.
9 o'clock.
Yeah, what time works for the defense on the 27th?
8 a.m. Mountain.
9 o'clock.
And that should work here too.
Which will be here for the purposes of the media. 9.
Your Honor, I'm sorry, will this be a live hearing in El Paso?
I was going to do it by Zoom. I was keeping it that way because I thought everybody agreed to that.
Well,
Yeah.
we'll do whatever the court wants, of course.
I would prefer Zoom. If somebody wants to request an in-person, then I'll have to make other arrangements. But the current deal is 9 o'clock here in Bexar County, 8 o'clock Mountain Time. So there's no confusion. I'm gonna send the same Zoom ID, and I'm gonna start the meeting at 9 a.m. Bexar County time. Y'all log in 8 a.m. Mountain Time, and we will go straight through.
Very good.
Is the court report going to be available then? I neglected to ask, but I'm hoping somebody can cover us on Tuesday.
We usually have a docket around that time, Judge, but if I can't do it, I'll get somebody.
All right. Well, I appreciate that.
Thank you.
Are you clear on the time and the date, Natalie?
No, Judge, I was sending, I got kicked out really quick, actually. I was
Judge, so it's Araceli. So it's gonna be September 27th at 8 o'clock.
Correct.
Okay, I'll be sending you a court setting, Judge, and then you can sign it for me, and that way we can e-file it.
That's fine, but it's a recusal. It's kind of in standard. When you file one, you're supposed to be ready, like if it's called that day. So I'm accommodating the state to the extent that we're going to do it Tuesday, but no further postponements. If you're missing a witness, you'll have to proceed without them.
Understood, Your Honor.
Okay, so you'll send me that setting and I'll get it back to you.
I will, Your Honor. I'll go ahead and send it to you right now.
And you can put on that setting, it will be broadcast on YouTube. Texas Courts. And it's under my name, Sid Harle, Harle. My YouTube channel, but it's posted on the Texas Courts through OCA, Office
Yes,
of Court Administration.
that's the one I've been providing them with, Judge, but they actually want like the Zoom link.
I mean, then they're just going to be in the waiting room.
Right, and that's the information I've been providing them with the YouTube channel.
Well, that's what we're going to do. I mean, witnesses and participants and parties will be on the Zoom ID. Media spectators will be on the YouTube.
Okay, sounds good, Judge.
All right, gentlemen, we will see you then. Thank you very much for being here and being on time, and we'll get it resolved September 27th, 9 o'clock my time, 8 o'clock your time.
Good.
Thank you,
Thank you, Your
Honor.
Honor.
Sounds good. Thank you, Judge.
Thank you very much for your help. Thank you, Natalie.
Thank you, Judge.